This week on Lewis on the Law, I've got yet another great show for you. I've got attorney D.A. Wilson on with me, and we're going to talk commercial leases.
Welcome to Lewis on the Law.
You are listening to Lewis on the Law. My name is James Lewis, and I am so excited. I've got a great friend of the show, attorney D.A. Wilson, back on with me, and we're going to talk commercial leases today. Now, D.A., I know your law firm does business law and taxes. Why don't you tell us a little bit about your practice area?
Yeah, sure, James. Thanks. I'm a transactional business and tax attorney here in Atlanta, Georgia. Most of my clients are small business owners, and I represent them, I say in a holistic fashion: business law, tax law, a little bit intellectual property, and sometimes it seeps over into real estate and commercial leases. So this topic is really, really relevant to what my clients face on a day-to-day basis.
Nice. And of course, I have had my share of commercial leases. I spent stints in my career where I've done nothing but review commercial leases.
Yeah, this is your topic, man. I'm excited to hear what you have to share.
Nice. So, you know what? I think we should talk about this first, like the way I would approach this with a client.
Absolutely.
I mean, I think the first thing that clients first don't really get why they need an attorney to do a lease or to negotiate their lease. And I think there's a lot of hidden things in a commercial lease, and there are a lot of elements to it. Some of them can be 100+ pages long.
Oh yeah, absolutely. I mean, I've come across some that are, like you said, 50 to 100 pages, and it's got a lot of them have teeth in them, and they're very dense.
They have a lot of teeth, and sometimes people don't even realize the teeth
until it's too late.
Until it's too late. Until they're, and I have a couple of cases right now where I'm litigating commercial lease discrepancies, and that's something you guys don't want to happen. So I want to start this off with talking about the recovery type, and when you're talking about recovery type, you're talking about how the three big basic expenses are, and the three big basic expenses they look at are like real estate taxes, building insurance, and operating expenses. Mm-hmm. And oddly enough, it doesn't include utilities for some reason.
Oh, wow. Okay. Well, I guess it makes sense.
Yeah, though utilities can be a huge expense.
Yeah.
So the first of these types is called a full service gross. And that's basically when the landlord pays all the expenses. That means it's in the lease somewhere where he's covering the real estate taxes, he's covering the building insurance, and he's covering the operating expenses.
Got you.
And the second type we're really talking about is a triple net, and that's what landlords really like to do to you. They like to pass all these expenses on to you, the customer, the client, or the tenant.
Yeah, I represent a couple landlords, and I've dealt with the triple net, so most familiar with that one. But you're absolutely right; they're throwing the burden on the tenant 100%.
Yeah, and as we see when we get into the operating expenses section. That triple net lease can be really, really hidden in the operating expenses, and people don't even realize how the landlord is passing all this on to you. But
absolutely,
sure enough, the landlord doesn't want to pay out any money; he just wants to collect off of his property.
That's it. No overhead, no nothing.
And if you're a landlord, I don't blame you. And matter of fact, you should be paying especially good attention to how the operating expenses are structured, because that's where the landlord can pass along all his expenses on to his tenants.
Yeah.
And tenants, if you are out there, you need to make sure that you understand how the operating expenses work, because that's where a lot of these expenses are going through. I think the last one of these types of recovery types that I just want to touch on basically, and I just want to touch on this basically because we're going to spend more time on other topics, is the modified gross, and that's exactly what it sounds like. Basically, he pays a couple of the items, and the tenant pays the other couple of items, or vice versa. Tenant pays a couple of items. It's really the same thing, but it's split.
In your experience, what's the most common of the three? What do you see the most? Is there an average or?
Well, I think if the landlord's going to cover something, he usually covers something like the building insurance or the taxes. The operating expenses are an animal unto themselves, you know?
Gotcha.
And so I think landlords usually don't cover the operating expenses because they want a nice juicy operating expense clause to be placed into that lease.
Got you. Okay.
And if I was representing a landlord, that's what I would suggest. I would suggest, if you're going to do some kind of modified gross, you want to go ahead and maybe take the insurance on the building. You want to cover that and then pass on the taxes and especially the operating expenses. Even if you take on the taxes, pass on the operating expenses.
Pass on the operating expenses. Make sure I remember that.
Yeah, right. And I think we're going to get a little bit into why the operating expenses are so important. I consider when constructing, and this show is really about basic lease construction because we're not going to get into the full depth of commercial leases because there's a lot of different clauses. There can be amendments. There can be LOIs. We're not going to get into all that. We're going to touch on the basics of lease construction for this show.
Gotcha.
And so, operating expenses. And operating expenses are the clause in leases where a lot of these lease expenses can be passed through to the tenant. You can pass them off as operating expenses. You start off by saying, okay, he pays a pro rata share of the building's operating expenses. And that basically means depending on his square footage, it's either based on the building size or the project size. And depending on his square footage, that's the percentage of the expenses that he pays. And that seems fair at first. We're going to get into some other technicalities that can bump what looks like a pro rata share up into something much higher than you expect. And I think something important and why you have to go through these operating expenses carefully as a tenant and why as a landlord you really want to focus on these is because the operating expenses are the places where you can vary management fees. Say you have a private company that is managing your property. You can go ahead and bundle their fees into the operating expense. You can bundle the administration fees of your own company into your operating expenses. Just call it admin fees and do something like, we'll do 10% of the operating expenses for administration fees. And so you can bundle all that back. And people look at that and their eyes just gloss over. They're like, management fees, administration fees. What does all that mean?
Those darn lawyers, right?
Yeah, exactly.
Sneak stuff in there.
But that's where all these expenses and then operating expenses take on a life of their own. They become like a second rent almost.
Oh, wow.
Yeah. So, I mean, they could for big commercial projects, they can take on a whole entire life of their own because you can have like utilities built in there. You can have this is where he passes through his triple net expenses to you. You can have the real estate taxes, the insurance, and the CAM costs. And the CAM is your common area maintenance.
Oh, wow.
Yeah. So he can pass a bunch of these expenses all through the operating expenses. And that's why when I talk to clients, I tell them, you really want to go through these provisions because this is the heart of a commercial lease. If the landlord, and most of them are represented by a crafty attorney, if he's represented by a crafty attorney, they've structured the operating expense clause to pass along almost all of his expenses so that he is not stuck paying anything then.
And so let me ask you a question because this is very interesting. Is the operating expense clause a provision? Is that standalone by itself? Is it something that's titled as such, or is it one of those paragraphs in a 6-page provision or whatever?
Well, when I draft them, I like to draft and lay them out carefully and clearly. So I like to create operating expenses as its own category or its own clause within a lease.
Gotcha.
And so I'll usually title a lease with operating expenses, and in that I'll include CAM, common area maintenance, and if he does a triple net, you'll include taxes, insurance, and this is where you realize whether you're getting all these pass-through expenses.
Nice.
And then in that you can also do the increases and you can write in an increase in controllable expenses. There'll be a whole bunch of controllable expenses that the landlord uses, especially the common area maintenance stuff like property maintenance and property maintenance, trash, all these things. These will become controllable expenses, and they can be passed on, and you can increase the controllable expenses by year. You usually throw in a little percentage in which you can increase the controllable expenses per year. Another careful thing another thing that tenants really want to, and this is from the tenant perspective, you want to make sure that you have audit rights placed into the operating expenses because the landlord, if you don't have, not to say your landlord's going to cheat you, but sometimes there are mistakes that are made. And so you want to have some provision where you can audit the landlord's records after a certain period under certain criteria. You get thrown that and audited. We're at the end of this section, though. That went by really fast, and I don't think I even got through operating expenses fully. Yeah. DA, why don't you give them some contact information for you?
Sure. Once again, it's DA Wilson of the Wilson firm here in Atlanta, Georgia. Phone number is 470-223-8271, and my email is da@wilsonfirmatlanta.
You're listening to Lewis on the Law. My name's James Lewis. I have a fun show going on with you right now. I have attorney D.A. Wilson on with me, and we are talking commercial leases. When we get back, we're going to wrap up operating expenses, and then we're going to get into some of the most misunderstood clauses, Estoppel and SNDA clauses. You are listening to Lewis on the Law. My name is James Lewis, and we have yet another fantastic show going for you. I have attorney D.A. Wilson on with me, and D.A. does business and tax law. D.A., why don't you talk about your firm a little bit?
Sure. Thanks, James. Again, it's D.A. Wilson of the Wilson firm. Office is located in downtown Atlanta, and I transactional business and tax attorney. I represent small businesses primarily, and in a holistic approach, business, tax law, a little bit of estate planning from time to time, and intellectual property.
My name is James Lewis, and you can contact me at jameslewislegal.com. You can email me at james@jameslewislegal.com, or you can give me a call at 404-610-0075. And if you have problems with a commercial lease, you need one drafted, you need one negotiated, or you need one litigated because it's been messed up by somebody or someone along the lines, go ahead and give me a call. If you have a topic you'd like to hear on this show, go ahead and go to my website, jameslewislegal.com, go to the last page, the contact page, and go ahead and hit me with your topic or your question, and we'll try and get to it on air. Once again, the information you hear on this show is not designed to replace the advice of an attorney. If you have a serious legal issue, if you're in a commercial lease dispute, you're in a tax dispute, go ahead and call DA. You need some transactional work done, call DA. If you're in a commercial lease dispute, you might want to give me a call.
Please, don't call me.
I've got a couple of commercial lease litigation actions going on right now. But anyways, don't take the advice or what you hear on this show. This show is meant to empower you and to deliver you information, but it is not designed to replace the advice of an attorney.
And James, I just want to jump in there and piggyback on what you said about retaining someone with an expertise in real estate law, because a lot of clients don't understand how niched real estate law is. And so attorneys like yourself who specialize in that area of law, it's super important for a client to get someone and not just get a random transactional attorney or whatnot like myself. I don't do much real estate law at all, and I typically send it out to attorneys like yourself. So I want to definitely emphasize the point of understanding how specialized real estate is. It may seem like an ordinary lease, but it's not. So give James a call.
Yeah, that's right, because this stuff can get complicated, and you guys don't want to go through litigation, because once you have to call someone in like me for litigation, the price goes up dramatically.
Way up.
Yeah, go ahead and get it right the first time. Get a professional to draft that lease or negotiate that lease for you. Okay, when we left off, DA, I was getting into operating expenses, and I'm going to continue it because operating expenses are more important than people realize.
Absolutely. And I want to ask you a quick question, though, about audit rights. I mean, I've read a couple leases before, but I never thought about the ability to be able to negotiate that. And so what are some of the things that a tenant should be looking for in those audit rights, maybe ask for in the audit rights?
Well, first thing, you want to be able to have a time period, and preferably it's a long period, to both review his controllable, his expenses. You want to be able to ask for that, and you want to be able to review that. You want to have a good, decent amount of time to review that. And then if there's a discrepancy, you need him to go ahead and pay for your expenses in auditing that, and have some allowance for the discrepancy too. I mean, there's going to be expenses involved, especially once it becomes into a dispute. Now, the catch to this is if you have a provision there where he's paying for your expenses, if you audit him and you find that there's a discrepancy that's greater than, say, 5% discrepancy. But the problem is if you audit him and there is no discrepancy, he may want that same provision back and say, so you want to be careful with that. You want to make sure that you don't, and you know, if I'm representing the landlord and a tenant says, okay, I want audit rights and I want you to pay the fees if there's a discrepancy of greater than 5%. And then I'm a landlord and I'm saying, okay, my bookkeeping is solid. You can have that. But if you audit me, create all these expenses, then I want you to pay my expenses when you find out that my bookkeeping is solid. And so there's a double-edged sword. You want to exercise your audit rights, but you want to make sure that you have a reason. Yeah. You know, you can't just say each and every single time. I mean, maybe you can get that provision in there, but usually there's something to say, or landlords will put into place a stop. But you do want that in there because there'll be times when you're like, wait a minute, there's 5 tenants in the building and there's no gross up and I am paying all these expenses. I want to see the books, and you may have good grounds. And sure enough, you come up with a 12% discrepancy or something like that. And, and the allowance is only 5%, then, you have a right to that money back. You have a right to, or if you commercial leases, the thing is, it's a contract. I mean, it's a contract. So, and when you enter a commercial lease, the courts expect you to have some knowledge. They don't expect you to be, a complete novice. Though lots of novices enter commercial leases.
Absolutely.
the courts expect you to have a little bit of savvy. And so when you enter into these commercial leases, you're entering into a contract and you're bound by those terms. I mean, unless there's some ambiguity in those terms, and we'll get into that a little bit later, but unless there's something like that in those terms, you're just stuck with that.
Wow.
Yeah. So, if you say 5%, it's going to be 5% a discrepancy. If it's 4.9%, you're wrong. You're paying his expenses and you need to cough up the money.
Wow.
Yeah.
It's good stuff, man. Thank you.
Yeah, no, it's awesome. And I love this stuff because, I spent a lot of time back in my days with the Beltline and then with my first major corporate job, which I will not name the company because there are people who listen to this show. And
there's no free advertising.
Yeah. So, and did a lot of commercial leases. And then I spent a brief time reviewing commercial leases.
Nice.
Yeah. So. And I was just talking about gross up. And gross up, you're going to see that language in commercial leases every now and then. You'll see it, and people are like, I don't know what that means. It's like 100% gross up, 95% gross up. What in the world does that mean? And so that is fancy language to say that if the building is rented, say, less than 90%, they'll give you a number in there. If it's rented for less than 90%, you're going to be responsible for the operating expenses all the way up to as if it was a 95% occupancy.
Oh, wow.
So say you're the only tenant in a building, okay?
Wow.
And there's a 95% gross up. You can be up to, it may just be up to 50%, but it could be up to 95% of the operating expenses you're covering.
Oh, wow. So this is what you were mentioning earlier about
the pro rata share. They put the pro rata share in there, and you're like, okay, I'm only paying 13% of the operating expenses on this building. And then you get your bill, and you're like, wait a minute, I'm going to audit you because that's not right. But then you look at the lease, and it says 95% gross up, and you're having to pay that expense because you signed that contract. And that's what the contract said. It's not up to you because you didn't understand the contract. You should have gotten an attorney to help you understand those. You should have gotten an attorney to help you understand those terms that you're agreeing to. And that's why the gross up provision inside an operating expenses, there's a lot of these provisions inside an operating expense clause that really passes on a lot of expenses. And the landlord's viewpoint is you're the only one in the building. all the operating expenses are yours anyways. So you might as well pay for them all.
Even if it's a strip mall, right? You're on one corner. This is all you.
Well, now this is the way that comes in. Sometimes it's the operating the expenses, the pro rata share of the building you're in, and sometimes it's the pro rata share of the project. And the project can mean the whole. And you want to get that term, what the project is. You want to get that carefully defined because it could mean the strip mall. It can mean the strip mall and the couple of buildings next to it that are all owned by the landlord. Wow. So you need to make sure all these terms are defined in there.
Oh man, these dirtbag landlords, man.
Hey, wait a minute. I like landlords. If you guys, I love you guys. If you guys need someone to draft your commercial leases, go ahead and come to me. I'm all right with you. But you're right. Some landlords are disreputable. But I don't think there's anything disreputable about making money in America.
No, it's business, and so listen. I take that back. I represent several landlords as well. I don't do their leases, but I do represent a few. So,
and I'm sure your landlords are good guy landlords.
They're good guys because they pay on time.
Right, pay on time. You gotta love that. You're listening to Lewis on the Law. We're at the end of this segment, and I don't think we still got all the way through operating expenses. But in this next segment, we're going to go on. Remember, don't take the advice you hear on this show to be advice, legal advice. If you have a serious legal issue, contract with an attorney. You can always contact me at jameslewislegal.com. You can give me a call at 404-610-0075, or you can email me at james@jameslewislegal.com. I have attorney D.A. Wilson on with me. D.A., give them some contact information for you.
Sure, D.A. Wilson of the Wilson Firm. Email is da@wilsonfirmatlanta.com. Phone number is 470-223-8271.
You are listening to Lewis on the Law. My name is James Lewis, and I am here with attorney D.A. Wilson, and we are talking commercial leases today. It is a great subject. I love it a lot, and we're getting into it. D.A., why don't you give them some contact information for you real quickly?
Sure. It's D.A. Wilson of the Wilson Firm, located here in downtown Atlanta. Website is wilsonfirmatlanta.com. Email is da@wilsonfirmatlanta. And phone number is 470-223-8271.
You are listening to Lewis on the Law. When we left off, we were talking about operating expenses. That section actually went on for 2 segments, so that went on way too long.
It's good stuff, though.
It is good stuff, and it's really important, and people don't understand how all of a sudden they're getting, and especially, I mean, if you're a sophisticated commercial real estate tenant and you've got these things going all the time and you're wheeling and dealing, then you know the way this works. Your eyes are wide open. Common area maintenance, gross up expenses, increases in controllable expenses, all those things are natural language for you and the attorneys that work for you. But if you're not used to it and you're trying to wheel and deal, a strip mall that we were using, using that as an example, then you can get hit with these bills from your landlord, a second rent as basically, and you're like, what in the world is going on?
What did I get into?
Yeah, exactly. And you watch your funds dwindling because you did not account for it. You need to be careful. You need to take a look at the operating expenses. They can be the heart of a commercial lease. So I want to get into some clauses that a lot of people, even a lot of attorneys, are confused about. And the 2 that I see the most are the Estoppel Clause and the SNDA Clause. And
Estoppel, that's an interesting word.
That is an interesting word, and I think it at its root it means you're stopping someone from asserting something. I know Estoppel. First time I heard it in law school, I was like, what? Estoppel? It took me a long time to even figure it out. And different legal areas use it in a completely different context.
Yep.
And the way we're about to use it is in a different context, because the Estoppel Clause, even though it is something that is weighed against the tenant or is a burden of the tenant if the landlord asks for it, it's designed to stop the tenant from asserting certain issues or bringing up certain issues. And Estoppel Clause is basically is a writing that the landlord can ask of you, and usually they ask you to execute it within 14 days or 10 days or something like that, that says the lease is still good. The landlord has not defaulted, and there are no major issues. And landlords use this when they want to bring in a second mortgage or something on the property, or they want to place a primary leaseholder over you. They want you to go ahead and execute an estoppel clause or an estoppel writing, so that they can give this to the mortgager or whoever the primary lien holder on the property will be, and say, look, everything is in order here. All our records are in order. My tenants are happy here, and so they ask you to go ahead and go ahead and execute the estoppel clause.
Nice, good stuff.
Yeah. So a lot of people don't get that. It can be written in there very, very in different ways where it may not even be labeled. A lot of times I like to label these things when I'm drafting a commercial lease, but sometimes they're not labeled, and especially estoppel and SNDA, they can all get lumped into this one big category, and so I think SNDA is another one that people kind of get confused, and that's subordination, non-disturbance, and atonement. SNDA, it's really 3 separate clauses, but it's called an SNDA clause because they're interlinked.
Gotcha.
Yeah. So, and it works with an estoppel clause because, and we're going to use and I use the term lien holder, but usually it's in the form of a mortgage on the property. The landlord on the property decides to take a mortgage on the property. And so this is going to become a superior lien to a lease. And a lease is an interest in the property. Yeah. But when a landlord takes in a mortgage or takes on a mortgage on the property, he may ask you to execute a subordination, an SNDA writing. And so that is basically, and he may not, it may be automatic. A lot of times it's self-operative or automatic within the lease. Gotcha. And that just means that if there's a primary lien holder, you've already agreed in the lease that your lease is subordinate to that primary lien holder. And that may be a mortgager, lender, or it could be another purchaser of the property. So it's automatically, and sometimes he has to ask you to execute that. And a lot of times when I do it, I like to make it automatic because the less paperwork that you force a landlord into, the easier it is to work through these.
Few leases I've worked on, no one's ever asked. So okay, I imagine it was in there.
Yeah. The SNDAs are usually in there.
Yeah.
And it's definitely something you want to take a look at, because if you're going to subordinate your rights to a primary lien holder or a mortgager or a new purchaser to the property, you want to make sure that they don't take your lease and say, okay, we're kicking you out now.
Absolutely. Yeah,
and that's where the non-disturbance part of it comes in. Okay. Because if you're going to execute a subordination, you also want the non-disturbance right to be in there. So you want that language to say, okay, I agree to subordinate to a primary lien holder, but I also want to be if I do that, I want non-disturbance rights. And that basically says they're going to honor your lease.
Nice.
And,
okay.
And,
all right.
And the third part of that is the atonement. And that's basically your agreement that new primary lien holder, that new purchaser of the property, is now your landlord, and you're going to pay him rent. And so those 3, and that's why the SNDA is usually lumped together, because it kind of works together. And sometimes it's thrown in there with the estoppel because all of that can work together, especially if the landlord is doing some exterior financing and using that property as collateral or selling that property.
Nice. That's good stuff, man.
Yeah, I think, and it's really important to know, definitely, and it's very confusing for a lot of people. And it's good that we talk through this.
Yeah, and so, in a practical sense, is the estoppel and SNDA provision, is that one, or are they separate provisions?
I like to make them separate, and I like to clearly label them. But I have seen commercial leases where they're all where it's all in one, and
Gotcha.
And maybe not even labeled as such. It's just paragraph 10, and then they start writing.
Oh wow!
I like to do paragraph 10 estoppel and then write. Paragraph 11 SNDA and then write. But some people will just some people will just lump it all together.
You're a friendly lawyer. That's good.
Well, I just like to have a clear roadmap through my leases. I think it helps both the landlords and the tenants.
Absolutely. Good stuff, man.
Good stuff. So, okay, let's talk a little bit about some other clauses because I think they can be very, very important. So you have repairs clauses, and a lot of times you want to make sure that, especially if it's a building, that you understand who has the responsibility for maintenance of the roof, the structure of the property, and the HVA system.
Yeah. Now, is this something that would be included in a triple net lease? Or it could be?
It can be included in common area maintenance.
Okay.
And usually it's spelled out, and usually that'll be in your operating expense where it says repairs, and then it'll say repairs, roof structure, and building systems, or repairs, roof structures, HVAC, building systems.
Gotcha.
So usually if it's passed through as a common area maintenance expense inside an operating expense, which becomes part of your triple net, then it's usually written in there, and it's usually written in your CAM provision or your operating expense provision, and that's where you'll usually find it in a lease.
Okay.
So at least from my experience, I'm sure people can hide it other places.
Yeah.
And sometimes people will just go ahead and give it its own provision, and the operating expenses will refer to repairs, and then they'll outline repairs in a separate provision, and they'll outline which ones are covered and which ones are not. So another one I want to get into is the holdover provision. And I think this is really important for landlords to go ahead and make sure that they have this in, and that tenants understand what it means. And I'll use my experience at the Atlanta Beltline, for example. We had a major client rent some of our property for one of the Midtown music festivals. And this is a major national client.
This isn't going well, I can tell.
Yeah, it's not going well. Anyways, they left all their stuff. Well, after the music festival was over with, they left all their stuff in one of our parking lots. And,
wow.
And you would think that an organization as sophisticated as that would take care of these things in the lease, but they didn't.
Oh, wow.
Yeah, so we had to write them many threatening, and I was the one writing them
Wow.
demand notices. That was my job there. They're like, okay, you can write the notices. That's the only thing we trust you with, are the notices at that point. I got into drafting other stuff, but in the beginning, it was just notices. Okay, we're at the end of this segment. DA, give them some contact information for you.
Sure. DA Wilson of the Wilson Firm here in downtown Atlanta. WilsonFirmAtlanta.com. My email is da@WilsonFirmAtlanta. Phone number is 470-223-8271.
You're listening to Lewis on the Law. Once again, this show is not designed to replace the advice of an attorney. If you have a serious legal issue, you need to go ahead and contract with an attorney. If you have some tax issues, if you have some business issues that you need to deal with, go ahead and contact DA Wilson. This is a great guy, a great attorney. If you have a commercial lease you need written, please contact me. You can also contact him too, but I could use your business.
No lease work. Go to James.
You're listening to Lewis on the Law. When we get back, we're going to talk more clauses and clauses and clauses. You are listening to Lewis on the Law. My name is James Lewis, and I am happy to have my good friend and a friend of the show, DA Wilson, attorney DA Wilson, on with me. DA, will you give them some contact information for you again? Because if you got business or tax issues, you need to go ahead and contact this guy.
Please do. It's the Wilson Firm here, located here in Atlanta, Georgia. WilsonFirmAtlanta.com. Email is da@WilsonFirmAtlanta. And my phone number is 470-223-8271.
You're listening to Lewis on the Law. My name is James Lewis, and as DA pointed out earlier, I am a specialist, and I specialize in real estate law, and I handle commercial leases. So if you have a commercial lease issue, go ahead and contact me, jameslewislegal.com. You can email me at james@jameslewislegal.com, or you can go ahead and give me a call at 404-610-0075. Once again, that's 404-610-0075. All my old shows are archived on my website, so you can go to my website. You can see the videos that we've done here. You can see all the podcasts, and better yet, This show is now national. Our podcasts are streaming live and nationally on every single national streaming platform you can think of.
That's awesome.
I know it is. It's really cool. We are even AI compatible. You can go to Alexa and say, Alexa, play Lewis on the Law, episode 45 with attorney D.A. Wilson. And guess what? We're streaming.
Oh man, that's awesome! I feel like a celebrity now.
Yeah, basically are. We're getting there, DA. We're working our way up the ladder, right?
Slowly but surely.
Slowly but surely. It's a struggle. Let me tell you what. Okay, when we left off, we were talking clauses, and I think we left off with repairs. I'm not going to get too much more into that. I want to talk about holdover. Holdover is definitely something you want to look at because landlords can hit you up with the holdover provision and say that if you're still there after the lease, term of the lease is over and you haven't negotiated a new lease, that you can be liable for up to 150% or maybe 200% of your rent. So that can be a steep leap. You want to know what's in that. You want to know if there's a holdover provision and what's in there as a holdover provision. And if you are a landlord, you want to make sure you write that in there and because it's a hassle. You can't, your property is held up. You can't negotiate a new lease. You can't get a new tenant in there. So, you have a right because your property is being held up by a tenant who's holding over. I want to talk a little bit about business hours because a lot of people overlook that. They're like, business hours. Why do I have to worry about building hours or business hours? And
it seems intuitive, but
it does. Well, if you have a building and they have their building hours from 6 a.m. to 7 p.m. and then it's closed after that, then that's something you want to know up front and you actually want it written in your lease. And landlords, you want to go ahead and specify your building hours in your lease. And that goes in with an integration clause. And I'm going to jump back into building hours and why it's a big issue. I'll highlight it because I have a case in litigation right now that involves building hours. And then it also involves the integration clause. Because landlords, you guys write in and there's always an integration clause in a lease and in a lot of contracts. And that basically integrates any writings that happen before the lease, any negotiations that happen before the lease. It basically limits everything to the four corners of the lease. So you've integrated everything within that lease document. All the relevant terms are in the lease document. But what happens when you've left something out of your lease that's not covered? What's happened when there's an ambiguity in your lease that is not easily definable? What happens then? Does your integration clause really take hold? I mean, if there's an ambiguity in your lease, if you've left things out of your lease that are not covered, that become an issue later, well, then some of those prior writings might be admissible under the parole evidence rule. And parole evidence is just bringing in outside evidence that's not in the four corners of the lease into, say, admissible evidence in court.
Now, have you encountered any of those in practice? Did ever come up?
I actually, thanks for asking that question because I want to get into it a little bit. It's perfect because so I have a client and I won't get too much into it, but there's a building hours issue and they negotiated building hours and that there are no building hours in the lease. There's no hours of access in the lease at all. There's no access provision, nothing in the lease that speaks to that. And so the landlord decided to change the hours at which they had access, and they had to have access in the evening for their particular business.
Oh, wow.
Yeah, so they had to have some evening access to the building. And the landlord was like, yeah, we don't like that anymore. So in the middle of the lease, they said, no, you can't have access to the building anymore.
Wow.
Yeah, so and then what happens there? Now you are stuck calling in someone like me to look through the lease to start sending the landlord demanding notices saying that he now has a material breach of your lease because hours, though they may seem like something small, can become a material provision of a lease if your business is dependent upon those hours.
That's interesting. I represented a client that has a gym, and it's a 24-hour fitness
Exactly.
facility. So I never thought about that until now. Thank God I didn't review the lease, but that would have been a material.
That becomes, if your business is dependent on hours, if you have a late night business, if you have a 24-hour gym and you need those doors to that building to stay open, or at least you need your clients to have access to that, that becomes a material provision of the lease. And maybe the integration clause doesn't limit that lease to those four corners anymore because no one's addressed that. And it's weighted against the person who drafted the lease. So if it's a landlord who drafted the lease, left that out, and then conveniently changes that, well, it can be weighted against him.
Okay, good stuff.
Yeah, good stuff. So a lot of people don't take that into account, but those type of things are really careful. You want to make sure that your lease is carefully gone through. I want to get into assignments and sublease now because
this comes up a lot.
It does come up a lot, and people can have their lease existing for a while, and their business is not doing well, and you know what? They're like, I want to sublet a portion of these premises out, or I want to assign my lease to someone else. And you would think that you could do that, but usually in a lease, and if I'm drafting the lease, there are all kinds of provisions guiding how that assignment or sublet goes. And if there's not, then there you have this huge gray area, and it can become an area of litigation.
Nice.
But you definitely want to structure that assignment or sublease clause in your lease, because the landlord can have all kinds of rights here at issues. First, it's going to cost the landlord, if you're subletting the property or assigning that property to someone else, the landlord wants to make sure that other new tenant is creditworthy, is the type of tenant that they want in that building. So there's going to be so the landlord should have provisions within that assignment clause or sublease clause that allows for them to review any potential assignee of that property, and maybe limit who can be an assignee of the property and who is allowed to be an assignee of the property automatically. And then the landlord should also have the right to recapture. Say you want to assign that lease, or you want to sublet a portion of the property. The landlord might say, you know what, you want to assign it or sublet part of it, but I'm not down with that. I just want that part of the property back. And so then he is exercising his recapture right. And that becomes extremely important, because some people will take a space and demise it, or use separate sections of the space and decide that they want to make money off of those. Say, you have a 15,000 square foot warehouse, and you want to cut it up into different spaces, and you want to sublet out sections for office spaces or different things. And, that might seem good and okay, but if you are a good landlord and crafty, you want to make sure that you are maybe have a chance to recapture, or you get some sort of profit clause in there. And that's where you get a part of the excess rent that they're capturing. And it may just be 50%. I mean, as they say in the good old days, just enough to wet your beak. Maybe it's just 25%, but you want to recapture some of the profits that are going on there. And it's perfectly acceptable, and it's a very standard provision in an assignment clause or a sublease clause. So I think we're getting close to the end of our show, but I do want to touch on just a couple of things. Make sure you check out how the rent is being escalated. Sometimes the rents are not escalated, but a lot of times they're escalated in different types of increments. You can have CPI, Consumer Price Index, and there's several different ones, and I don't want to get into that because that's not really my area. I just look at it and I see the Consumer Price Index, and then I look it up. But you can have a fixed rate that they escalate by. You can have a percentage that they escalate by. You can have other rent factors in there, like the profits, the excess rents that are shared. And if you're a venue, perhaps the landlord has asked for a percentage of ticket sales. That happens a lot when you're doing venue leases.
Nice.
So that is all the time we have. DA, hit them with some more contact information for you again.
Sure. Once again, it's DA Wilson of the Wilson Firm. Email is da@wilsonfirmatlanta. WilsonFirmAtlanta.com is the web address. And phone number is 470-223-8271.
You're listening to Lewis on the Law. My name is James Lewis, and I want to thank DA for coming on with me and having a great show.